Reflections with theologian Father James Bacik, lecturer and campus minister at the University of Toledo.
I think our long history of tradition of civil debate and of working things through the political process probably will be in our favor as we go about all of this. And we also have the terrible experience of the Civil War to see what happens when you really can't debate it or don't work it out properly.
Today on Reflections, Father Bacik talks with Father Robert Kirchner, a priest from St. Clement's Parish in Toledo, Ohio. The topic of this week's Reflections is the abortion debate, legal considerations. And now, here is Father Bacik.
Well, Bob, let's talk a little bit about the so-called Webster case, the new Supreme Court decision about abortion and the Missouri state law. It's certainly fostering a lot of debate at the moment, and it's going to continue to do so. I was thinking of it in terms of the larger experience and legal procedures in the rest of the Western world. I know I've read some things that indicate that there's a much greater sense in the other Western industrialized nations for restricting abortion. I mean, there seems to be a general sense that the fetal life is deserving of respect and that there has to be certain restrictions on abortion. And I guess there's also sort of a stronger social context that you need to have support for mothers and children and so on. So could we, I don't know if you want to say much about that, what happens in other industrialized countries along this line or not.
Well, I don't know an awful lot about what happens in other industrialized countries. I have enough trouble keeping up with what's happening here. But I do think one has to remember that that may be the right response, a right response for the wrong reason, because those countries come from a corporate or corporate estate background, a lot of them, that tends to regard the individual much more as belonging to the property of the state, and so that while I don't think any of them have that feeling to that point any longer, nonetheless I think that idea is floating around in the background of their political and legal reflection and universe of discourse, and I'm not sure that that's a healthy thing. We have a great tradition of the freedom of the individual so far as possible, certainly at least from the state, that the individual person has his own autonomy, and along with that autonomy, part of our tradition, and this is part of the whole debate on which the thing turns, a responsibility. In the measure that we are free, in the same measure we are responsible. If I have no choice about doing something, then obviously you can't come up and say, why did you do that? I can just say, I had no choice. I was not free. I'm not responsible for it.
And we, of course, in the United States here have this long history of pluralism, and we've constantly been trying to figure out how to live in this pluralistic society. We have a great history of it, and we've made great strides in it. We've been a model in many ways for figuring out how to get along. We have disparate people who came here, different religious backgrounds, different outlooks, and for a lot of years now we have figured out to live in some sort of harmony. We had, of course, the Civil War, which disrupted all of that, but for the most part we've been able to debate our questions and to finally work out some mode of living together in this democratic and pluralistic society. Now, we find ourselves threatened again, I think, in this whole abortion question. There's the violence that we see on both sides, and that is an unhappy sort of situation, and we begin to wonder, well, how are we ever going to work it out, and what sort of rational basis can we have for reaching a public consensus, which will be the basis for effective public law. So I think our long history of tradition of civil debate and of working things through the political process probably will be in our favor as we go about all of this. And we also have the terrible experience of the Civil War to see what happens when you really can't debate it or don't work it out properly.
Yes, although in the political order I think that leads to almost inevitably to compromise, and from an ethical point of view, compromise is something that doesn't seem to be in sight. Certainly, I think that there is much more common ground between those who tend to favor access to abortion and those who would deny it than is generally thought. I think that we have to go and search out those values. But with regard to public policy, the idea of maintaining the public order, I think very often we have to compromise and we have to live with some things that we would prefer not to have to live with. But by the same token, that's the price we pay for getting some of the things that we consider of great importance.
So you've sort of distinguished their public policy from particular moral positions.
Oh, yes.
And so we can't have that kind of compromise on moral positions. I mean, if someone believes that abortion is the killing of human life, then there doesn't seem to be any real compromise available at that level.
That's
on the
right.
other side,
Yeah.
for people who see the issue almost totally in terms of the state and the rights of pregnant women, are going to be favoring the upholding of the rights of women, and are going to say, well, I can't compromise on that. I can't let these women down. Women
That's
have enough
right.
trouble, and I have to be by their side and stand for them in this particular situation. So on both sides, there's a moral high ground that they are occupying, and there seems to be no room for compromise at that level. And nor, I think we can never ask people to do that. I mean, you and I know that in pastoral counseling, you can't, if you ask someone to compromise their principles, or they do that for the sake of another person, you got an unhappy person on your hand.
That's
you
right.
think of a marriage situation. If someone compromises their moral and religious outlook in order to go into the marriage, well, there's a good chance it isn't going to work, because they're going to always feel guilty or upset, or feel, I gave so much, now you ought to give to me. I just think you can't do that in human affairs.
That's right. The whole idea of the Western tradition of ethic and of morality supposes that there are right answers to every question, even though the achievement, the mastery of those right answers very often lies beyond our reach. But nonetheless, the supposition that there is a right answer supposes then that I can't say, if I think that I perceive it in its application in a particular context, that it's not so. The whole concept is that. But that's a different matter.
Public policy
The public
is another
policy, the
question.
public order is a different thing. It's keeping the public peace, and that's a different kind of matter. And that, of course, is one of the things that I think was perhaps bad about Roe versus Wade, is that it tended to drag a particular ethical or moral view into the arena of public policy. It put an end to political debate, as a matter of fact, and made debate about the abortion issue ever since Roe versus Wade purely academic. But by the same token, it came up, it was addressing an area where the law had never been very successful anyway. I know people who are very thoughtful people who are profoundly convinced that abortion is, in principle, wrong. That it's the taking of the unjustified taking of a human life, and yet at the same time believe that Roe versus Wade, at least in its effect in striking down restrictive abortion laws, was defensible. I don't entirely subscribe to that position myself, but at the same time they were simply pointing out there's some things, as we should have learned in the Prohibition era, that law cannot do, and we cannot ask it to become something else than what it is, or to play some other role than what it should play in life.
There's another distinction here that we could keep in mind, and that is between the legal order and the political order, it seems to me. That, I mean, the court deals in legalities, supposedly. The political order we usually think of as governed by the Congress and the executive branch, and that in the political order, the people in our democratic society try gradually to work out solutions to problems and to come up with laws and public policies that reflect some sort of consensus. What we've effectively had in the Webster case, it seems to me, is throwing this matter back into the political order.
Yeah, well, that's suppose I wouldn't draw that sharp a distinction between the legal order and the public order as the political arena. I think what happens really is that the law generally tends, when the public debate and the political forum has achieved the measure of compromise that everybody can live with, is that legally then that compromise is enshrined in the laws. And
well, Roe versus Wade went the opposite way.
Well,
We
exactly.
didn't have any sort of political consensus.
That's right. It didn't express a consensus, and the lawyers have had for a long time a phrase that describes that situation exactly when they say that a matter is not yet ripe for decision. And as you suggest, it seems quite clear now, in the light of what the Supreme Court is doing, that it is finally coming around to the judgment that the matter was not ripe for decision, and that the violent debate that's going on ever since then, or not debate so much as the violent expressions of repudiation or of support that decision gave rise to, are ample proof that the matter was not ripe for decision.
Let's just go back to Roe v. Wade and recall what it really effectively did. And I guess what it said is that states really could not have restrictive laws, and I mean it distinguished out trimesters, right?
Yes.
And it said that they really could not make laws during the first trimester that would prohibit abortion, right?
Yeah, and that they took away every kind of, as I recall, and it's been a while since that thing came out, but as I recall it, it took away any kind of consideration on which the state could prohibit abortion during the first trimester. Now, there's the practical thing that's involved in that, and that is that by the very nature of the case, it's pretty hard to see that abortion has taken place. In fact, early on in a pregnancy, to establish some kind of thing, it would seem to be an ineffective law. But what the court was doing was appeared to be repudiating the principle that the society or the father of a child, an unborn child, or the family had some kind of claim upon the mother who was bearing the child. And that seemed to be the real difficulty. Then the state could bring in some limitations that concerned maternal health during the second trimester of pregnancy with abortions, because it becomes a much larger, if you will, medical problem apparently in aborting a child in the second trimester. And in the third trimester, that the state might very well be able to pass legislation which would be reflective of a concern for fetal health.
Now, what has happened with the Webster decision is that it is now put back in the hands of state legislatures, and we're going to find a lot of efforts to write more restrictive laws within the various states. You're also going to find efforts within the states to write laws that will protect the rights of women. And it's going to come down to votes in the state legislature, and it's going to be a matter of electing candidates in the next election. It's going to be a major issue for sure in the election. So in that sense is what I meant, that it takes us back to the political process.
That's right, exactly.
And I think it's at least, I realize that that's going to be bring all kind of difficulties, and people are going to, debate's going to be hot and heavy. But in the long run, it seems to me it could be of value. That is because it's our really only chance to solve the problem. The problem can only be solved, it seems to me, if we find enough consensus, enough middle ground to produce a public policy that we can live with on both sides. I think that's what we have to get, and debate at the state levels might well further that.
Yeah, the tragedy, I think, that one can nail on the framework of Roe versus Wade is that when the debate resumes, it is going to resume among people who have been driven to positions far more extreme than they would likely have been driven to had not any effective decision-making process been taken out of the hands of the community by the court. And so that the debate arises anew with a real pertinence and a real potential effect in public policy, but wounded, grievously wounded, with a great scar of this bitterness that has grown up on both sides over the last 13 years. And so that the quality of the debate, I think, has beyond all question been profoundly hampered by what the court did in 1973.
Bob, let's look at some material that I'm borrowing from Father Richard McCormick. He's a Jesuit theologian, one of our outstanding moral theologians. He wrote an article called Abortion, the Unexplored Middle Ground, and it was in a journal called Second Opinion, March of this year, 1989. And in there, he lists 20 different things that he thinks can serve as a basis for this unexplored middle ground. He's trying to come up with ideas that we all could agree on. So he has things like this. There's a presumption against the moral permissibility of taking human life. Presumption against that. He thinks we ought to get agreement. And he says abortion is a killing act. We ought to be able to say that straight out and so on. Now, getting down to the focus we're taking here on the law side of the legal side, he points out at number 10 in his listing, says Roe v. Wade offends many people, and so did previous prohibitive laws. He said we really ought to be clear, and I think you've brought that out, that it was, in a sense, from our viewpoint at least, out of the Catholic tradition, is that it was, premature kind of law, that it didn't reflect the public consensus. It offended a lot of people's sensibilities in the country. Now, next point he makes, he says that he thinks we ought to be able to agree on as part of this debate, is that unenforceable laws are bad laws. And of course, when you start thinking about that in the United States, we think immediately of prohibition. And so prohibition really was not enforceable, and it produced the speakeasies and a lot of crime and so on. And eventually prohibition had to be repealed precisely because it wouldn't work. And why wouldn't it work? Because there was no public consensus, no public philosophy that stood behind it that people had general agreement on. And therefore people just said, well, we're not going to abide by it. And they went ahead and broke the law, and you ended up with all kind of crime and so on. That I think, in McCormick's viewpoint, would be an example of an unenforceable law, and therefore his conclusion is that's a bad law. Do you tend to agree with that?
Yes, I think I would draw a distinction from what Father McCormick says. It's a tremendously important point. I think that prohibition was unenforceable, and I think this is probably true of laws with respect to that would prohibit abortion, is that the very nature of the material, the subject that you're dealing with, makes it difficult, in fact, to verify whether the law is being broken or not. It's not just a matter of the consensus, which is certainly one consideration that makes a law difficult of application, but the other thing is that it's just hard to get at the facts. The people who made bathtub gin or beer in the basement or wine in the cellar, although making wine, of course, was legal for a household up to 200 gallons as a result, incidentally, of the Prohibition era laws, but it was hard to verify that the law was being broken. And if you have a law like that on the books, and it's easy to break, then it seems to me that erodes respect for the law in general. Mm-hmm. Now, the thing is that you might say that there are probably a lot of people who don't like the income tax laws. But the point is that it's fairly easy, given the IRS and its survey of that whole business of income and record keeping, it's fairly easy to verify if somebody's breaking it, and therefore whether there's a consensus on how much tax we have to pay or how it's paid, nonetheless it is an effective law in the sense that it's enforceable.
There's another aspect of this unenforceable law that he suggests here. He says that there may not be a public willingness to enforce the law.
Mm-hmm.
I wonder how, if we start applying that to restrictive abortion laws, what would we end up saying about that?
Well, I think the same thing is true. I think that you would find eventually, and there are a lot of there's a lot of precedent for this kind of thing happening, that grand juries won't indict and trial juries won't convict. The once in a while, when you read all the people, all the things that people say when they take a look back at England. When there were 200 or 300 capital offenses on the books, and that a boy could be hanged, as I think it was Dickens pointed out, for stealing a shilling, which wasn't very much money even then. The plain fact was that that so violated the common sense of the community that unless an accused was so obviously antisocial, grand juries wouldn't convict and trial juries wouldn't indict and trial juries wouldn't convict.
So we've got an unenforceable law, and we've got one that is a bad law, therefore.
Mm-hmm.
And we're trying to get sort of agreement on that point in this debate. Now that gets concrete before long, and it becomes a matter of what sort of laws are going to be written. Let me take up an example here. He says that we ought to be able to get agreement that we should write some law, some public policy, which restricts abortion.
Mm-hmm.
That we shouldn't, that there's a general sense of this. I think that it plays into the idea that there's a strong feeling in the American public, I think, that abortion just for convenience is not a good thing.
That's right.
I think there's many polls show that,
mm-hmm.
that the American people just are not willing to go along with that. Abortion for convenience doesn't make sense, so it's sort of morally repugnant for somebody to say, well, I want to take a vacation to Europe this year, so we're going to have an abortion.
Mm-hmm.
And that's not just a pro-life position in a sense, or just a position of the Catholic Church. I think that there's a general moral sensibility along that line.
That's right. I've seen a lot of surveys that purported to show, and I think it's probably true, that people would live with a law, for example, that in principle prohibited abortion except in cases of a threat to the life of the mother or incest or rape, something of that sort, and that people could many more Americans would be willing to live with that kind of a law. Now, once again, you run into the problem of the practical enforceability of it, what kind of burden you're putting upon the instruments of the laws to enforce that law. But at the same time, at least in principle, that represents a policy statement about the value of fetal life. And that, I think, that there is a value, that the fetus is not simply a negligible bit of organic material, biological matter, but something much more than that is, I think, a value that most Americans could agree with.
McCormick makes the point that to begin to talk about where you would make any restrictions is valuable because it forces the question of why you would make the restriction, why you would do that. Even if you'd say, I think abortion just for convenience is wrong, the next question you could ask in the debate is, well, why do you think that?
Sure, precisely.
Now, one possible answer to that is, well, is just what you said. That is, well, I think that is potential human life.
Mm-hmm.
That's nascent human life. Someone else might put it more strongly and say, well, I think that that's wrong because that's a person.
Mm-hmm.
Or, and you'd have to begin to answer that question.
Oh, yes, and that, looking for that value extends. That's why I think that there's some consideration that has to be given to the idea of the extension of that whole issue of the value that's going up there to the whole range of human life. After all, and I don't want to, for a minute, to be taken as saying that the pro-choice people are like the Nazis with regard to the extermination of the Jews. But by the same token, they both raise the same question, and that is, why do we assign a value to human life at some stage or other, at least of its development, that is a distinctive and fundamental value? And that if it can be eroded in one area because of convenience, then you get at the other end of the business the question of how we deal with the elderly and people who are no longer economically productive, people who are perhaps not particularly relevant any longer to the world around them. And then we get to the problem of politically unpopular minorities in a society, and you really begin to run into profound questions about what it is about human life that is distinctive, and that, I think, is part of the contribution, incidentally, that Christianity in a distinctive way throughout its history has made to the whole development of the Western ethic.
That's, I think, a really important point. You'd probably want to rethink your analogy of even of the use of the term the Nazis. I mean, if we're going to move our debate forward and find middle ground and watch our slogans and language, I think we probably have to be careful of that.
Oh, yeah, that's why
I would want to be careful about it, but and I think you would too.
But people would make too easy a jump.
Yeah, but the point
principle involved is
that's what we want to get after.
The thing we have to get at. That's right.
And I don't know quite what the answer to that is. And I suppose if you turn it around, I mean, what are the pro-choice people going to say to us? I think their telling question is probably, well, what about the pregnant woman? Mm-hmm. I mean, what sort of empathy do you have for the pregnant woman? Sure. What about the rights of the pregnant woman? What are you going to do for her? And I think that there's a really telling point there. One of the things is that we ought to have alternatives for that woman.
That's
we ought
right.
to care for that woman.
And quite apart from empathy, one can say that society has a real value given the wondrously fertile creativity of the human person. One has to say that a society which condemns women, or many women of childbearing age, to be barefoot and pregnant, as the old saying goes, is robbing itself of the distinctive kinds of contributions that they could very well be in a position to make, given greater opportunity to exercise the kind of freedom that gets stated or claimed, sometimes in an exaggerated measure, in this whole debate.
Now, we're focusing, Bob, on the legal aspect, in a sense, of this, the law question, and we're looking at the abortion debate and what happens after the Webster decision, and we're looking at Richard McCormick and some of his suggestions for a middle ground. And one of his other principles, he says, an absolutely prohibitive law on abortion is not enforceable. That flows from his other question about unenforceable laws are bad laws. He says an absolutely prohibitive law on abortion is not enforceable, and he says it in two ways. A law would prohibit all abortions, even in case of rape and incest. And you used that example before. and in cases where the life of the mother is at stake. And he says the other thing by this absolutely prohibitive law would mean the destruction of the human being from the moment of conception, not taking into account the pre-implantation period before the fetus implants in the mother's womb. So he says an absolutely prohibitive law is not enforceable, and I think that he makes that case well. I mean, in our society today, given the public posture on incest and rape, just to take two examples, there's a strong element in the country that says that abortion should be allowed for those situations. Our president says that often. There are Catholic moralists who agree with that. There's a large percentage of the Catholic population that goes along with it, just to speak in our own terms. And so you begin to wonder how such a law could be enforceable. And on the other side, I mean, an abortion that was dealing with the pre-implantation period, it becomes, you just can't verify.
Well, sure, that's right. That carries to the extreme that makes it perfectly plain that this is an area where it would be impossible for the law effectively to be administered when you can't even tell whether pregnancy is taking place. The morning after pill, for example, is obviously the kind of situation in which you technically, if you say an absolutely prohibitive law isn't going to work, that's what it means, that there's no way that you can verify that a violation of the law has taken place.
And of course, this says something, about what sort of public policy position are we going to take. I think it points out how difficult it is. So what have we got? We've got an idea here that you have to have some sort of restriction. The majority of people in the United States want some restriction on abortion. They don't just want abortion for convenience. On the other side, you've got people saying that, well, for rape and incest and for the life of the mother, that we have to allow for this. Now, does it become possible to write a law around that? Around those sorts of concerns and the amount of consensus we have. I think that's the kind of question that we're going to be facing.
Yes, I do think that, as a matter of fact, there were laws before, state laws in various states before Roe versus Wade. I don't know this for sure, but I have the distinct impression that there were laws which were framed exactly that way.
Yeah.
And,
we might well get back to that as we go along. Well, Bob, there's so many aspects to this thing, and that the debate is really complex and difficult. We've been trying to look at what are the aftermaths here of the Webster decision, and it's going to promote new debate, and we're looking for some sort of common ground. And the ones that we suggested here were the ideas that unenforceable laws are bad laws, and the other idea there's got to be some sort of public policy restrictions on abortion, and finally that absolute prohibitive laws against abortion really are not enforceable at this point. That might provide at least some framework for continuing the discussion.
You've been listening to Reflections with theologian Father James Bacik, lecturer and campus minister at the University of Toledo. Today on Reflections, Father Bacik talked with Father Robert Kirtland, a priest from St. Clement's Parish in Toledo, Ohio. The topic of this week's Reflections was the abortion debate, legal considerations. If you have any comments on today's show or suggestions for future programs, please write Father James Bacik, Catholic Campus Ministry, 2086 Brookdale Drive, Toledo, Ohio, 43606. Funding for this program was provided by the Catholic Communications Commission of the Diocese of Toledo.